You're driving home late one night after working and you haven't gotten much sleep in the last few days. You look in your rear view and see police lights flashing, and you get that nervous, anxious feeling. Your heart immediately starts thumping in your chest. You interact with the officer, who mistakes your bloodshot and glossy eyes for being under the influence. Although she doesn't smell alcohol, she gives you the field sobriety test and decides to arrest you for suspicion of driving under the influence of drugs. At the station, they ask you to take a urine test. While you may not be currently under the influence of weed, you've smoked a few days ago. What do you do in that situation? In this week's video, I'll be explaining how the courts and prosecutors treat DUI marijuana in the District of Columbia. My name is Joseph Scrofano, and I'm the founder and managing partner of Scrofano Law PC, where we fight relentlessly on behalf of anyone in trouble who cares about their future. Driving under the influence for marijuana is basically the same offense as driving under the influence of alcohol in DC. It's a serious crime in the District of Columbia. For first offenders, DUI charges carry a maximum penalty of 180 days in jail and/or $1,000 fine. Having said that, there's no felony DUI charge in DC. That means the offense is a misdemeanor no matter how many times someone gets arrested for it. It could be someone's 10th DUI and it's still a misdemeanor. However, DUI cases in DC are the only misdemeanors in the entire DC criminal code that carries mandatory minimum jail sentences under certain circumstances. Mandatory minimum jail sentences require a judge under the law to impose jail under certain circumstances when the person is convicted. That means the judge could literally believe that the defendant was Mother Teresa. But if convicted under certain circumstances, the judge has to impose jail. The fact that DUI cases carry potential mandatory minimum sentences, unlike any other misdemeanors in DC, shows you just how serious the DC criminal legal system takes DUI charges. Given the fact that weed has been legalized in the District of Columbia, it's obviously become more socially acceptable and more widely available. And as we've previously discussed in other videos, the DC City Council first decriminalized, then ultimately legalized possession of small amounts of plant marijuana. Now, while marijuana still remains illegal under federal law, this drastic change in local law has made weed much more easy to access. In fact, we've done previous videos on the legality of gray market cannabis businesses in DC and why DC technically still has no legal recreational dispensaries. Demand for marijuana has grown and use has either increased or at least become more out in the open. In fact, it's hard these days to walk around certain parts of the city without getting a whiff of that sticky, icky. That said, driving under the influence of marijuana or any other mind-altering drug, including prescription medication, remains illegal. Law enforcement has had decades to standardize and refine its methods for detecting alcohol-related impairment in drivers. There are breathalyzers and standardized field sobriety tests dedicated to detecting alcohol impairment and measuring how much someone may have had to drink before driving. The same technologies and methodologies do not exist for DUI marijuana. The standardized field sobriety tests, or SFSTs, do not give any accurate information to the officer about whether someone is under the influence of marijuana. But the officer will still administer the SFSTs where they suspect marijuana impairment. Breathalyzers only purport to measure alcohol consumption, not drug use. There are also no generally accepted studies that indicate how much marijuana it takes to interfere with an individual's ability to drive, or how recently the marijuana has to have been smoked to interfere with the person's driving abilities. In addition, DC police will ask an individual they arrested for DUI to take a urine test. And it's well known that cannabis can stay in someone's urine up to a month or more. That means you could get arrested for DUI and have not smoked weed for weeks, but it will still show up in a urine test. And prosecutors in DC will not listen to the argument that because weed stays in one's urine for so long, a positive urine test for marijuana is not accurate evidence of whether the defendant was actually under the influence while driving. Add to all these complications that DC has really bad case law for DUI cases. In fact, there's specific cases from the DC Court of Appeals that have stated the government can prove and convict someone for DUI by alleging that they're under the influence of a drug without even proving or arguing which specific drug they think the person took. DC judges also do not ordinarily require the government to put on a drug recognition expert to prove their case. In fact, as far as we know, the main police agency that arrests individuals for DUI in DC, the Metropolitan Police Department, or MPD, does not even have a single officer trained as a drug recognition expert, or what they call a DRE. That means when pulled over, the person is largely at the mercy of the officer's untrained and unscientific observation, hunches, or suspicions about the individual's behavior. Now, having said all this, there are certainly some more obvious signs of being under the influence of marijuana. Having a half-smoked joint in the car's ashtray when pulled over would certainly be solid evidence that the driver may be impaired with weed. But what about having unburnt marijuana that's under the legal amount for possession? These all create complicated issues for enforcing and prosecuting folks for driving under the influence of weed. Unfortunately, DC police and prosecutors tend to err on the side of punishment. They believe deterrence is more important than pesky notions like proof beyond a reasonable doubt, science, and justice. If asked to take a urine test, doing so just gives police and prosecutors evidence to use against you that may not even actually prove you committed the crime. Driving under the influence of marijuana is just as serious as driving under the influence of alcohol. On top of that, it's harder to prove, and you are more likely to be falsely accused. If you or a friend or loved one are arrested for DUI marijuana, contact us for a free consultation. And if you're interested in criminal legal issues like gun laws, cannabis laws, drug laws, go ahead and like and subscribe to our channel, as we'll be putting out more videos each week about criminal law in the DC, Maryland, Virginia area.